and Madam Fatini. We are from Tutorial 5. Based on our analysis of the assignment question, we have identified 5 legal issues relating to the discharge of contract. These issues mainly involve the doctrine of discharge by performance and discharge by frustration under the Contract Act 1950. In this presentation, we will discuss each issues by applying the relevant legal principle, statutory provision and case authorities to the facts of the case. Now, let's move to the first issue.
Let me start with my first issue. The issue is whether time was of the essence of the contract and whether Emerald's agreement to extend the completion date to 31st March 2025 amounted to a waiver of that requirement, and if so, whether Emerald validly reinstated time as of the essence by issuing the 14-day notice on 15 January 2025. Let's move on to the law part. Under section 56 subsection 1 of the Contracts Act 1950, where time is of the essence of the contract, failure to perform within the stipulated time renders the contract voidable at the option of the innocent party. In the case of Tan Ah Kian versus Haji Hasnan, the court held that time is of the essence where it is expressly stated in the contract. However, the requirement that time be of the essence may be waived if the innocent party allows performance to continue after the deadline, as seen in the case of Sim Chio Huat versus Wong Tat Fui and Sharikat Houston Plastics Industry versus Sharikat Lam Seng Trading. That said, a single extension does not automatically amount to waiver, as held in the case of Sia Kui Mo versus Kulim Rubber Plantation. Where waiver has occurred, time may be reinstated by giving reasonable notice according to the case of Mensa Mercantile Far East Private Limited versus Ecobina Sendirian Berhad. Okay, in the part of applying the law to the facts, the original construction contract expressly stated that time was of the essence with the completion date of 31st December 2024. Under section 56 subsection 1 and in the case of Tan Ah Kian, there is no doubt that time was essential at the outset. In September 2024, Emerald agreed in writing to extend the completion date to 31st March 2025. Aman argues that this extension waived the strict time obligation. This argument relies on cases such as Sim Chio Huat, where the innocent party allowed work to continue after the deadline, thereby waiving time as the essence. However, the facts here are distinguishable. Unlike in Sim Chio Huat, Emerald did not repeatedly tolerate delay. The extension was a single extension and expressly conditional upon Aman maintaining reasonable progress. Under Sia Kui Mo, a one-time extension does not by itself destroy the essence of time. Therefore, the mere granting of additional time until 31st March 2025 does not automatically means Emerald permanently abandoned its right to insist on timely completion. More importantly, Aman failed to comply with the condition attached to the extension. Between November 2024 and January 2025, Aman's progress slowed significantly and construction eventually ceased altogether. This conduct shows that Aman was not proceeding diligently, which directly breached the condition upon which the extension was granted. Even if the court finds that the extension amounted to a temporary waiver, Emerald clearly reinstated time as of the essence. On 15 January 2025, Emerald issued a formal notice demanding that Aman resume work within 14 days. According to Mensa Mercantile, this constitutes reasonable notice, especially considering three things: the commercial nature of the project, the substantial delay, and the fact that Aman had already received Rs 9 million, representing 75% of the contract sum. Aman's response that it was financially unable to continue and it does not excuse non-performance. Financial difficulty does not discharge contractual obligation and does not prevent Emerald from enforcing its contractual rights. Therefore, Aman's failure to resume work within 14 days period amounted to a serious breach, entitling Emerald to treat the contract as voidable. In conclusion, time was originally of the essence of the contract. The September 2024 extension did not automatically waive this requirement as it was a single and conditional extension. Even if waiver is assumed, Emerald validly reinstated time as of the essence by issuing reasonable notice on 15 January 2025. As such, Emerald was entitled to rely on Aman's continued delay as a ground for termination. Thank you.
Hello everyone, and my name is Surdesh Muniswaran and my student ID is 253UU25577. The core legal question we must address here is whether Aman's cessation of work constitute a repudiation or a fundamental breach under the Section 40 of the Contract Act 1950, thereby entitle Emerald to terminate the contract. Under the Malaysian contract law, Section 40 deals with the effect of a party's refusal to perform their promise wholly. We need to determine if Aman's conduct meets this threshold. The material fact states that first Aman only completed the 75% of the total project. The progress began to derail when work slowed down significantly between November 2024 and January 2025 before the construction eventually ground to a complete halt. In response to this inactivity, Emerald issued a formal notice on January 15, 2025, and Aman's response to this notice is critical. They explicitly replied stating they were financially unable to continue with the project. Seeing that performance would not resume, Emerald officially terminated the contract on February 10, 2025. Now that we have discussed the fact and the main issue, we will look at the relevant law and the authorities that apply to this case. Firstly is the Section 40 of the Contract Act 1950. Under this section, Emerald can terminate the contract if Aman refuses to perform his contractual obligation or makes himself unable to perform the contract completely. Secondly is the doctrine of the repudiation. The meaning of refusal is explained through the doctrine of repudiation in the case of Rasia Monusamy against Lim Tan. The court stated that the repudiation requires a clear and absolute refusal to perform the contract. And in the case of Lovelock and Franklin, the court held that the repudiation can also be shown through a person's conduct, even if they do not expressly say they are refusing to perform. And the third one is the doctrine of the fundamental breach. A fundamental breach is a serious breach that affects the main purpose of the contract. In the case of Ching Yik Development, the court held that a breach of a fundamental term allows the innocent party to terminate the contract. And in the case of Hua Chia Ling, the court confirmed that the Section 40 reflects the common law principle of the fundamental breach. And for the contractual rights to terminate, apart from the law, the contract itself gave Emerald the right to terminate if Aman delayed the construction works or failed to carry out the works diligently. Therefore, both the law and the terms of the contract are relevant in deciding whether Emerald was entitled to terminate the agreement. Now, let us apply the law to the fact of this case. From Emerald's point of view, Aman clearly failed to perform the contract because Aman completely stopped the construction work. About the 25% of the project was still unfinished. Aman failed to complete the project within the agreed time. Aman admitted that it did not have enough money to continue the work. And for the legal effect, under the Section 40 of the Contract Act 1950, Aman made itself unable to perform the contract by stopping the work and admitting its financial problems. Its section also showed a clear intention not to complete the project. Based on the case of Rasia Monusamy against Lim Tan and Sons, this amounts to an absolute refusal to perform the contract and therefore constitute repudiation. As Aman repudiated the contract through its conduct and admission, Emerald was legally entitled to accept the repudiation and terminate the contract on the 10th February. Balance analysis, we must also consider Aman's possible defense. Aman may argue that it could not complete the project because of financial difficulties. Aman requested an extra Rm 1 million due to increased construction cost. However, Emerald only agreed to pay Rm 500,000. Aman claims that the lack of full funding caused its financial problems and prevented it from completing the remaining 25% of the project. However, this argument is not strong in law. Emerald was not legally required to pay the additional Rm 1 million. The only agreed variation was Rm 500,000 and Emerald fulfilled this obligation. Financial difficulties do not excuse a party from performing its contractual duties. Therefore, Aman cannot use its financial problems as a reason for stopping the work. Emerald's refusal to pay an extra Rm 1 million does not justify Aman's failure to complete the project. As a result, Aman remained in breach of contract and Emerald was entitled to terminate the agreement. Conclusion, Aman committed both a repudiation and a fundamental breach under the Section 40 of the Contract Act 1950. Therefore, Emerald was legally entitled to terminate the contract on 10 February 2025. Emerald may also treat the contract as discharged and claim damages for any losses suffered as a result of Aman's breach.
The issue is whether the contract between Emerald Development Sdn Bhd and Aman Building Sdn Bhd was discharged by frustration under Section 57 subsection 2 of the Contract Act 1950 due to the severe flooding and the government prohibition order. Next, we look into what are the relevant law that applies to the situation. So first, we have Section 57 subsection 2 of the Contract Act provides that a contract becomes void when an unforeseen event beyond the party's control makes the performance impossible or unlawful. To establish this frustration, the event must occur after the contract is formed and must not be caused by either party. In addition, Section 40 allows the innocent party to terminate the contract if the other party refuses or is unable to perform its obligation. And furthermore, we have Section 66 which says that any benefit received under a contract becomes void must be returned or compensated. Next, to support the principle of frustration, we have the leading case of Davis Contractors Ltd versus Fareham UDC. So in the case, the contractors faced labour shortage which delayed the construction work. However, the court held that the contract was not frustrated as the performance was still possible. So the principle is that mere increased difficulty or expenses alone does not amount to frustration. Another case, we have the Maritime National Fish Ltd versus Ocean Trawlers Ltd. So in the case, the plaintiff failed to allocate a license needed to operate the trawler and claimed frustration. However, the court rejected the claim as the impossibility was self-induced. The principle is that frustration cannot be caused by a party's own action. And in the case of Lee Sang Hock versus Fatima binti Zain, the land was compulsorily acquired by the government before the sale could be completed. So the court held that the contract was frustrated because the performance became impossible. So the principle is that the government action may frustrate a contract. Now, applying the law to the facts of the question, Aman may argue that the contract was frustrated because of the severe flooding on the 5th February 2025, which destroyed the substantial portion of the partially completed structure, and shortly afterward, the local authority issued a prohibition order banning all construction work for 2 years. And these events occur after the contract was formed and were beyond the control of the both parties, and the prohibition order made further construction unlawful, while the flooding significantly affected the project. Therefore, Aman may argue that the requirement of Section 57 subsection 2 are satisfied. And also, applying the Davis contractor case, Aman may contend that the flooding and the 2-year prohibition order fundamentally changed the nature of the contract. And Aman may also rely on the Lee Sang case because the government action in both cases made the performance impossible. Further, Aman may argue that the force majeure clause applies because the flooding and the prohibition order constitute acts of God and the government intervention. This exclusion Aman from the liability its failure to continue the construction work. However, on the other side, Emerald may argue that Aman had already slowed down and ceased the construction work before that flooding occurred. Aman had also admitted that it was financially unable to continue the project, and Emerald had already issued a notice requiring Aman to resume the work. And under Section 40 of the Contract Act, Emerald may also argue that Aman had has already committed a repudiatory breach before the flooding and the prohibition order occurred. And further, Emerald may also rely on the principle in the case of Maritime National Fish Ltd, which established that the frustration cannot be self-induced. Therefore, Aman cannot rely on frustration if its inability to perform was caused by its own financial difficulties and prior cessation of work. And further, Emerald may also argue that the force majeure clause cannot excuse breaches that has already occurred before the flooding and the prohibition order. Let's say if the courts find the contract was frustrated, the Section 66 will apply, and which says that any benefit received under the contract must be restored or compensated. In conclusion, although the flooding and the prohibition order may amount to frustrating event under the Section 57 subsection 2, Aman had already stopped and admitted its inability to continue the project before those events occurred, and applying the Section 40 and the Maritime National Fish Ocean Trawlers Ltd case, Emerald is highly likely to have a stronger argument. Therefore, the contract is more likely to be discharged by Aman's repudiatory breach, and Emerald may terminate the contract under Section 40 and claim damages for losses suffered. However, if the court finds that the contract was frustrated, the contract becomes void and any benefits received must be restored under Section 66 of the Contract Act.
Good morning, everyone. My name is Vijayadarshini Perempuan Uday Kumar, and I will be discussing issue 4, which concerns Emerald entitlement to damage for Aman's breach of contract and the type of damages that may be recovered under the Contract Act 1950. So the relevant provision is Section 74 of the Contract Act 1950, which provides that a party who suffers from a breach of contract is entitled to compensation for losses that either arise naturally from the breach or were within the reasonable contemplations of the parties when the contract was made. So the principle is based on the landmark case of Hadley and Baxendale, which established two limbs of recoverable damages. The first limb covers losses that arise naturally from the breach, while the second limb covers special losses that were reasonably foreseeable by both parties at the time of contracting. So in this case, Aman failed to complete the construction project despite receiving Rm 9 million and being granted an extension of time until 31 March 2025. So therefore, Emerald may claim damages for the losses caused by Aman's breach. The first head of damages claimed by Emerald is the cost of appointing a replacement contractor. So under the first limb of Hadley against Baxendale, losses that naturally arise from a breach of contract are recoverable. So when a contractor abandons a project before completion, it is a natural and foreseeable that the employer will need to engage another contractor to complete the remaining works. Applying the law to the facts, Aman completed only 75% of the project before stopping work completely. So as a result, Emerald was left with an unfinished commercial complex, which had no choice but to appoint another contractor to complete the remaining 25% of the works. So if the replacement contractor charges more than the remaining balance under the original contract, so the additional amount represents a direct loss caused by Aman's breach. Therefore, Emerald is likely to entitle the recover to reasonable cost of engaging a replacement contractor under Section 74 of the Contract Act 1950. The head of damages concerns delay losses. So the project was originally scheduled for completion on 31 December 2024. Although Emerald later agreed to extend the completion date until 31 March 2025. But Aman still failed to maintain reasonable progress and eventually ceased construction altogether. So as a result of this delay, Emerald suffered losses associated with the prolonged completion of the project. So this may include financing expenses, administrative costs, project management expenses, and other losses resulting from the delayed completion. Since these losses arise directly from the Aman's failure to perform the contract, they fall within the first limb of Hadley against Baxendale and are generally recoverable. So, however, MLN must provide sufficient evidence to prove the amount of loss suffered. Therefore, delay related losses are likely recoverable under Section 74 of Contract Act. This is the loss of anticipated rental income. Unlike replacement contractor cost and delay losses, this is considered a consensual loss. Therefore, it falls the second leaf of Hadley against Baxendale and will be only recoverable if it was reasonably contemplated by both parties at the time the contract was made. So, in this case, the project involved the construction of a 3-story commercial complex. It is reasonable to assume that the purpose of the development was to generate revenue through leasing or commercial activities. So Aman was aware of the nature and purpose of the project when entering into the contract. Because the building remained incomplete, MLN was unable to rent out the premises and consequently lost potential rental income. As such, MLN may argue that this loss was foreseeable and within the reasonable contemplation of both parties. However, MLN must prove the amount of rental income lost and show that the claim is not merely speculative. If sufficient evidence is provided, this head of damages may also be recovered. MLN is subject to the duty to mitigate its losses. According to the case of British Westinghouse Electric Co. Ltd against Underground Electric Railways Co. of London Ltd, an innocent party must take responsible steps to minimize the losses resulting from a breach. Therefore, MLN should act promptly to appoint a replacement contractor and avoid unnecessary delay. Any losses that could have been avoided may not be recoverable. On the other hand, Aman may raise several defenses. First, he may argue that the claim for rental income is too remote and speculative. Second, he may contend that MLN failed to mitigate its losses. Third, he may argue that the flooding and the government prohibition order was supervening events that contributed to the losses suffered. So, in conclusion, MLN has a strong claim for damage under Section 74 of the Contract Act 1950. The cost of appointing a replacement contractor and delay-related losses are likely recoverable as direct losses arising from the Aman's breach. Loss of anticipated rental income may also be recoverable, provided that MLN can prove that the loss was foreseeable and establish the amount of loss with sufficient certainty. That's all from me. Thank you.
So next we are addressing issue 5. Issue 5 is whether Aman Build is entitled to claim payment for the next 75% of construction work it completed before the project ground to a halt. Specifically, can Aman claim under quantumary or restitution despite the subsequent breach or frustration of the contract? So let's look at our first ground, which is Section 71 of the Contract Act, which provides for the statutory quantumary. So the law here is straightforward, where if a party lawfully does something for a person, like without intending to do it for free, and that another person enjoys it for the benefit of it, so they must pay for the reasonable compensation. Like crucially, in Section 71 does not care if the contract is alive or dead. So it operates purely on the preventing unjust enrichment. So applying this to our facts, by August 2024, Aman had completed about 75% of the commercial complex. Emerald clearly enjoyed the benefit of this work, and their own architect certified it, and they received a physical structure that was 3 quarters completed. So Aman is commercial contractor, and they obviously did not build this for gratuitously. So therefore, under Section 71, Emerald is legally bound to pay. And now because Emerald has already paid 9 million, which
exactly matches the 75% of the completion milestone. So the statutory debt is largely settled. However, if Aman can prove that the actual value of the work exceeds 9 million, they retain the statutory right to claim that shortfall. Our second ground looks at the nature of the contract itself. So using the established case law, the rule from Tong Aik and KP Kunchiraman dictates that we must distinguish between an entire contract and a divisible contract. So in an entire contract, it's all or nothing. Like you don't get paid a dime until the whole thing is built. But in indivisible contract, where payments are tied to like specific independent stages, a contractor can legally recover the payment for each completed stage. So the contract between the Emerald and Aman is clearly divisible. It wasn't a lump sum gamble. It expressly provided like 4 distinct stage payments tied to the architectural milestones. Because Aman successfully completed and received the certifications for the first 3 stages, and they are right to that 9 million crystallized under the Tong Aik principle. So they cannot claim that the 3 million because they never did the final 25% of the work. Again, the claim is satisfied but what has already been paid, unless the unsatisfied work between the milestones is proven. So our third ground deals with what happens when a contract becomes void under section 65 and 66 of the Contract Act. So the section 66 states that when a contract becomes void, such as through frustration, any party who received an advantage must restore it or compensate for it. So the federal court recently clarified this in Lim Swee Chu case, ruling that full restitution of the contract price is only available if there is a total failure of consideration, meaning absolutely zero performance. So applying this to our scenario, Emerald cannot physically return the 75% completed concrete building, so they must pay the financial compensation for the advantage. Following the case of Lim Swee Chu, because Aman performed 75% of the work, there is no total failure of consideration. However, Emerald has the right to set off. If Aman was in a breach by abandoning the site between November and January, so Emerald is entitled to claim damages for hiring a replacement contractor, delay losses, and the lost rental income. So Emerald can legally deduct those damages from any outstanding quantum merit balance owed to Aman. To conclude, Aman highly likely has the right to be paid for the 75% of the work they completed, which is heavily supported by the Section 71, 66, and